With the introduction of non-fault divorce on the 6th of April 2022, the government launched a new digital, online and paper service for those wanting to divorce. Here we will explain how the online digital divorce process works. The gov.uk website has some helpful information entitled Get a Divorce, breaking the stages down into 7 steps. From the 6th of April 2022, an application can be started by one person as a sole applicant or by the couple together as joint applicants. They do not need to give a reason for the divorce, other than a simple statement that the marriage has irretrievably broken down. These apply for divorces in England and Wales only. They vary for divorces in Scotland and Northern Ireland. If you are seeking to end a civil partnership, you must also apply to the court to do so. The practical legal process is the same as the application for a divorce. The conditions are: you need to have been married for at least a year, your marriage must be legally recognised in the UK, and it must have irretrievably broken down. To start the divorce, you will need the following pieces of information: full names and addresses of both people, any contact telephone numbers, email addresses if you prefer communication this way. Your partner can be served papers via email if you have their email address to which only they have access to, the original marriage certificate or a certified copy, and a certified translation if it's not in English. Proof of any name change if it changed since the marriage, for example, a deed poll or a change of name deed. You will need to pay a fee, which is currently £593 on sending the application to court. You will need a credit or a debit card to make the payment if you are wanting to use the online process. You may be eligible for help if you are on a low income or in receipt of benefits. You may be exempt from paying some or all of the fee, but you will need to make an application to determine eligibility by completing a form known as an EX160. You can get this application form online or complete an online application to get a help with fees reference number. You will be taken to a screen to start the creation of a secure login and then directed through the online process step by step. Whether you are applying for the divorce on your own or jointly with your partner, the application and details you give will be checked, and if accurate and correct, the court will send out the following: a notice that your application has been issued, a copy of your application stamped by Her Majesty's Courts and Tribunal Service, an acknowledgement receipt, this is for joint applicants only, and a case number. Joint applicants must complete all the documents together. They jointly apply for each stage in the process, so there needs to be cooperation throughout the case. If you are applying as a sole applicant, your partner will be sent a copy of the application and the information about how to respond to it. You will be told when they have been sent the paperwork. The timescales for responding will depend on whether they receive the court papers via email or via post. They are given a limited time to do this, and the court will advise you of the date by which they should. They should respond and either agree not to contest the divorce or confirm that they intend to dispute it, but they will need to have the ground to do so. If your partner fails to respond, the court will tell you what you need to do next. You will be advised how to apply for a conditional order, but you will have to wait for the appropriate date before you can. The court will tell you when this is. You will need to complete an application form online for processing. If you've applied too early, the application will be rejected. On review, the court will look at the application for divorce, your partner's response, and what you have said in the application. It must be satisfied that you have the ground for a divorce and that the documents are correct and accurate. If this is the case, you will receive a notice confirming that you are entitled to a divorce and confirming the date when the conditional order will be made. There is unlikely to be any need for you to attend court on this date. You will then be sent the conditional order once it is granted, together with the information about the next step. Once the conditional order is granted, you can ask the court to make a financial settlement order, because on or after this date, the court has the power to grant one. There is no power to grant a financial settlement order before the date of the conditional order. You will be advised how to do this, but you will need to wait at least 6 weeks from the date of the conditional order before being able to apply. If you apply too early, it will just be rejected. You are not divorced until the final order is made. Only on that date does your marriage formally come to an end. The court will send you the final order. This is an important legal document which you will need to keep safe. You may need to produce it from time to time as evidence of your divorce. If you lose or misplace it, you will be able to get a further copy from the court by paying a fee and giving the divorce case number. Just because you are divorced, this does not bring an end to the financial claims that you have against each other as a formerly married couple. These remain ongoing and could be brought at a later date. You would be recommended to deal with your assets and achieve a settlement so that you have a divorce along with certainty about your assets. Any delay in dividing them could prejudice the outcome, as valuations can fluctuate and personal circumstances can change. Remarriage can prevent financial claims being made if the original application for a divorce did not specify a wish to seek a financial settlement, or you received the application for divorce from your partner and didn't make a financial claim yourself. You must take legal advice before remarriage if there is no financial settlement order in place.